Welcome, everyone. I'm David Brannen. We're here today for Ask a Lawyer Live, our Wednesday edition, which means it's time to talk about employment, wrongful dismissal law, and the like. So today I'm going to cover the topic wrongful dismissal from employment. This will be of interest to anyone who's been recently let go from their job, or if you are a worker and you're interested in understanding your rights. I'm going to cover it from both a legal and kind of a practical standpoint, so you have a broad overview of how this works, and to make sure that if you are ever let go from your job, that you're treated, that you're given the proper legal amounts of pay and severance pay and notice. So let's dive into this. I'm going to get right to the presentation. I'm going to do another take. Well, actually, before we get to that, I do want to do a couple announcements, actually. Tomorrow is going to be our live show. I'm going to attempt to take live calls once again. I have a checklist, so hopefully it will go off without a hitch, and then we've worked out all the bugs for future episodes. Friday, I'm going to do a show on Friday. We're going to cover another type of form that the insurance company wants you to fill out. So what I kind of committed to doing, people want to know how to fill out these forms that they get from the insurance company. So whenever I see a new one come across my desk, I'm going to do a video on it. And I saw a new one come across my desk this week. So we're going to talk about that form, and I'll go through that all on Friday's show. Just watch. We'll schedule it in advance, so you'll be able to click a reminder to be notified that the show will go, or you can watch it on the replay. So let's dive into this. I'll start over so that I can get the intro for the clip video. We're going to clip this video out, and we'll clip this video out so that it can be played on replay. So here we go. Hello, my name is David Brannen. I am a disability lawyer and founder of Resolute Employment and Disability Lawyers. So I do both employment and disability law. Today, we're going to be talking about wrongful dismissal in Canada, what it means for employees. This will be good for you if you have recently been terminated or let go from your job, or if you're working and just want to understand your rights. I'm going to cover this for both a legal and a practical standpoint. Let's dive in. All right, let's dive in. So let's start with the basics. What is wrongful dismissal? Wrongful dismissal happens when an employer ends an employee's employment, a lot of employees there, or we'll just say when your employer ends your employment without giving you the required notice that you are going to lose your job. A lot of people think wrongful dismissal means that you were treated unfairly, but that isn't quite right. It's not so much always about unfairness. Legally, we're looking at whether you were given adequate notice that you were going to lose your job, or if they didn't give you adequate notice, kind of a heads up, that they're giving you an amount of money that would be equal to the amount of notice that they should have given you. Now, when I say notice, I mean letting you know that your job is going to end within 2 months, so you should start making preparations to find a new job. That would be giving you notice that your job is ending in 2 months. Now, depending on the amount of notice that you're entitled to get, depends on different factors that I'm going to cover here later in the presentation. Now, let's talk about the biggest misunderstandings that people have. So the biggest one is that people think that just because they've been treated unfairly, that is a wrongful dismissal. Unfortunately, that's not always the case. What can happen is you can be treated unfairly, but still be given the amount of legal notice or pay that you're entitled to get, even though it is unfair, or you've otherwise been treated unfairly, fired for not doing anything wrong, this type of thing. Now, another issue that we see come up is on the employer side. They will often, there are rules that allow employers to fire people without giving them any notice or any termination pay. And employers will often wrongfully think that they have a cause to fire someone without notice, when in fact they really don't. So it kind of works both ways. Also, people may wrongly assume that short-term employees, if you haven't been there that long, that you don't have any rights, and that's also not true. So these are 3 common misconceptions that you have to be careful if any of these apply to you. You've been fired without notice, or you've only been there a short period of time. You can still be entitled to termination pay. All right. So let's just go over the legal framework in Canada just as an overview. In Canada, there are two layers of protection. The first is the employment standards laws of each province, and also federally, if you work in a federally regulated industry, for example, like long haul trucking that goes interprovincially or into the United States. Now, the second layer, those statutory employment standards acts, they give the bottom floor of what your rights are, the bare minimum of what your rights are. That can be supplemented by your rights under the common law. This is judge-made law in Canada, and it sets out what people's rights are above and beyond the bare minimums allowed for under these employment standards acts. Now, the problem is most employers will only offer you the minimums that are required under these employment standards acts, but you may be entitled to much more than that under the common law. So what makes a dismissal wrongful? Wrongful can come from a couple of different ways. So first of all, it can happen if you're not given proper notice of the severance or your termination. That can be wrongful. So let's say that legally you're entitled to 6 months notice of termination, but your employer only gives you 2 weeks. That would be a wrongful dismissal because they did not give you the amount of notice that you were entitled to at law. So that would give you legal rights of recourse against them to get pay for the other weeks that were not paid to you as required under the law. So they tried to pay you for 2 weeks, but really they owe you 6 months pay, basically. All right, so the other one I've kind of talked about is it can be wrongful as well if the employer fires you without notice and basically says you're done, we're firing you because you did something wrong, and that's it. When you are fired that way, you're also not entitled to get employment insurance, which is also like a double whammy. This type of thing is often misdone by the employer. They will often believe they have cause to fire someone when in fact they don't. It is quite a high standard to meet this level to fire someone without any notice, and a lot of times employers get it wrong. So if they do that, that is considered a wrongful dismissal because they fired you without notice when in fact legally you were entitled to notice. Even if it was only the minimum amounts allowed under the Employment Standards Act, you were still entitled to some amount of notice. So how do we know what amount of notice you're entitled to get? It's not rocket science, but it's also an area that is difficult to make generalizations. Courts will do this on a case-by-case basis, looking at a number of factors to determine in your situation, what amount of notice are you entitled to? There are some general rules of thumb, but as we've seen with some recent cases, that these general rules of thumb are not always going to apply, and people can often get much more severance than would otherwise seem on the surface, given the kind of general rules of thumb that are out there. Now, the factors that they will look at things like how long you've worked there, your age, your pay, how easy, like your level of within the company in terms of management or executive, and also how difficult it would be for you to find re-employment with a comparable position and salary. Those factors all go in, and there are many other factors as well, but those are the main ones that will be considered to determine how much notice that you would be given. Ultimately, the goal here is to figure out how long they're trying to estimate how long it would take you to find a new comparable job. And again, they have to estimate because severance is paid out or determined at the time you're being fired, when no one has a crystal ball and can decide whether it's going to take you 2 weeks to find a new job, 2 months, or 2 years. So the courts have kind of come up with rules of thumb that they know that if these facts or factors are applying here, they tend to shorten or lengthen the time someone would need to find comparable employment. Okay, so some other things that could make it a wrongful. Oops, did I not go ahead here? Yeah, I forgot to move ahead. So I've talked about the age and length of service, job market, that kind of thing. The other thing would be that it can range quite a bit. It can range as little as 2 weeks up to 2 years or more of notice. Now, if you're going to get 2 years or more of notice, that means you're going to be at more of an advanced age, into your 50s, 60s, 70s. and that you have a position that you have been there many, many years, probably 20, 30 years with the same employer. And also that it's the type of job where you are not going to be able to readily replace it in the economy because you have a unique set of skills that are really only good for that company, or because of your level of education, you've maximized your earning ability by being at the same employer, and it will be almost impossible for you to transfer that over to a new employee or to a new place. With those types of situations, you're going to get many, many months of notice, up to 2 years or more. So just keep that in mind. All right. So termination with cause. Termination with cause can happen when you have done something that is so bad that the employer is allowed to just fire you on the spot without giving you any notice. Often employers will get this wrong, and many of the things they think they can just fire someone on the spot for, it is really not the case. What the courts will look for, unless it is something extremely, like something extreme where there's like a high level of violence or theft, something extreme. Usually these one-off incidents that someone might do that are ill-advised or not appropriate, these types of things will often not be grounds to fire someone without cause, but it would have been more appropriate to do progressive discipline. So the times when employers are successful with firing people for cause is usually where there is some extreme, some type of an assault or something very extreme that has happened, that where there's a danger to other employees and this kind of thing. That can, yes, that'll be a situation. The other one though is if they've documented progressive discipline with the employee. So started with a verbal warning, then a written warning, and then a final warning, and now you're fired. Like if they have done that, it is much more likely that the court will uphold that they have followed the right process and can terminate you for cause. But most employers do not go through that process. They will think that because you said maybe an ill-advised remark, something that could be seen as racist or insensitive, that type of kind of language in the workplace probably is not going to be enough to cause you to have grounds to fire you on the spot, but it would be enough for you to get a suspension, suspended without pay for a bit of time, a warning, or something like that. Okay, so termination, severance pay. Even when employers offer severance or termination pay, I'm just going to use those terms interchangeably. What they're offering you is pay rather than give you like 6 months notice. They call it working notice, meaning, okay, your job's going to end in 6 months. You can keep working here. That would be fine. Employers are allowed to do that. But what most employers, they don't want to do that. They want to just let you go today and pay you out 6 months. That is where this termination pay idea comes from. Now, just because the employer is offering you termination pay doesn't mean they're offering you enough. It's very common for employers to really err on the side of either the very low end of what you could be entitled to or way, way below what you could be entitled to. They do this knowing that many employees do not want confrontation and will just take the money and go try to find other work. And a smaller proportion of employees will get lawyers and fight back and try to get more money. So it's worth it for them to just give these low offers, knowing that maybe 6 out of 10 people will just take them and then they'll fight the other 4 if the people end up getting a lawyer. Often what employers will do is offer you the bare minimum that's required under the statutes for the province, or if you're a federally regulated worker, they'll give you the bare minimums under those provincial employment standards statutes or the federal one. That is often not enough. Sometimes it can be. It really depends on your situation. Situations where you may be limited to the statutory minimums are where your employment contract states that. So it is possible if you have a contract with your employer for your employment, you are allowed to contract out of the common law protections, so it will say in your contract, if it says that your compensation is limited to the amounts payable under your provincial Employment Standards Act, and that often will be upheld and you will be limited to those minimum amounts. Now, even if you have a situation like that, it's probably still worth having a lawyer look it over, especially in Ontario. The Ontario courts have shown like a real willingness to overturn some of these clauses that limit people's termination pay if they run afoul of the minimum requirements in the Employment Standards Act. Sometimes this can be very technical arguments, but courts have shown a willingness, even on these kind of technical kind of gotcha type situations, courts have gone along with it and said, no, we're not, these employers are sophisticated for the most part, and we are not going to let them create ambiguous employment contracts. So if there's any ambiguity, or if it appears that this could violate the minimum standards required under the Employment Standards Act, then we are going to void either the whole contract, or sometimes they will void the section that deals with limiting your termination pay. So I guess with what I would tell you is, with any case, you would want to ask yourself, did I sign an employment agreement? And if I did, what does it say about in there about limiting my termination pay? Now, some good rules of thumb are, if you're let go, it is a very emotional time. Can be very, very emotional. Sometimes employers will take advantage of that to try to pressure you to sign paperwork then and there, and make it seem like if you don't sign this now, then you might not get anything, or make some other threat. That is something you should resist. You have certain legal rights. They have to pay you no matter what. So you don't have to sign anything to get the amounts that are owed to you under the Employment Standards Act. So those amounts have to be paid to you no matter what. So if they're telling you you have to pay this in order for us to give you anything, it's not right. They have to pay a certain amount to you from the baseline Employment Standards Act and extend your benefits and these types of things, regardless of whether you sign anything. The reason that they will pay more is in exchange for you signing a release that would say you can't come back and sue them later on, you can't make a human rights complaint against them, or things like that. So they will often do a release in exchange for you to pay more. Ooh, we got some sun is coming in here. I might have to go fix my camera here. Yeah, I think I'm going to go fix the camera. Just give me 1 second. All right, see if that's a little better. I don't want to look like a glowing angel here. It's a little bit bright, but okay. So basically, the other thing you're going to want to get it in writing what the terms are that they're offering you, and confirming that they have in fact fired you. Most employers are going to do that. They're going to give you a termination letter. That's the standard practice to protect them and you. Sometimes it could come in an email or a text. You want to keep evidence of when they are saying that they terminated your job and what they've offered to pay you. Most employment lawyers will review this for you. Some will do it for no charge. Some will do it, you'll have to pay to get a review done. But ultimately, they can tell you the pros and cons and whether it makes sense to get a lawyer. A lot of people contact us, and my response to them is, yeah, in theory, we could get you more money, but you are going to have to pay legal fees. And if you go on EI, you're going to have to pay that back. So sometimes it's possible to get more, but it's not practical to do so because you may not come out further ahead. Sometimes the best deal is the one you're offered right away. If they've offered you something that is a reasonable low end, on the low end of what would be considered a reasonable settlement offer, if they give you that right away, a lot of lawyers will tell you you probably should just take it because they're offering to pay it now. You don't have to get a lawyer. You don't have to worry. You can go back to work. If you find work early, you don't have to pay anything back because they're offering to pay it all out now. So there's a lot of reasons why sometimes the best decision is just to take the offer, but I would still get legal advice on that to make sure that that is the case. Now, just some examples here. These are kind of based on clients I've had. I've changed the facts a little bit, but a manager dismissed after 15 years. So I once helped this person. They were dismissed after 15 years with no cause, but they were offered very low amount of money, barely above what's required under the employment standards. So in that case, I did encourage them to hire us to go after the employer to try to get, in their case, we were going after around 16 to 18 months of pay is trying to settle for that amount. This person could get, best case scenario at trial, could have got up to like 20 months, probably, maybe a little bit more. But we were trying to settle in that somewhere in the 15 to 18 range. And can't remember where we ended up on that one. I think it ended up settling around 12 months worth of pay. So about a year's worth of pay, which is pretty good. Especially given the person had prospects to get more work, the case didn't have to go to trial and such. So, but it all depends. Sometimes it just matters how long you want to fight it, but you have to keep doing like a cost benefit analysis to figure out if fighting longer will net you more money, or if you are just doing it for principle and you're not going to get more a financial gain from it. Another one I represented where I have to be careful on the details here because there's a non-disclosure agreement, but we'll just say the person was doing contract work for a fitness center, we'll call it, and they were put down as a contractor and fired. So if you're a contractor and fired, you're not protected. You don't have protections under the Employment Standards Act, so the employer doesn't have to give you notice. They just have to do whatever it says in the contract. And the contract in question just said, actually, there was no contract in question. Yeah, I don't think there was a contract in that case. Let me think about that for a second. Was there a contract? I don't think there was a contract. And if there was, it didn't really. Now, there was no contract. There was no contract. So it was really unwritten. This person was a contractor. Was there a contract? I think there actually was a contract now that I'm thinking of it. Yeah, there was definitely a contract. So there was a contract, but I think the terms around, I should have looked at it before I came on here, but the terms around the termination, I think that the person could be terminated with like 30 days notice or something like that. That's something like that. So they were basically terminating 30 days notice and just paying them out for the classes they were supposed to teach at the fitness center for the last couple weeks, those last 30 days. That's exactly what it was. So that person saw me and I was like, you know what? Tell me a little bit more about this arrangement, because this does not sound like you were a contractor. This sounds like you were an employee. So if you're an employee, you're going to be entitled to more than 30 days notice. You're probably going to be entitled to like up to 6 months notice. So a lot more money than just them paying out your classes that had to get canceled here over the next couple of weeks. And that is in fact what happened. So we were able to negotiate based on this person being an employee and got them a lot more money. Now, the reasons there, I won't go into all the details, but there were enough indicators that this person was not a contractor and was acting like and was treated like an employee by the company, even though both sides thought of it as a contractor relationship. Now, this last one is my favorite type of case because we are a disability and employment law firm. So quite honestly, the best cases for us are the ones where there is a mix of disability, sick leave, and a termination type situation. My favorite cases to do are ones where people are terminated after being on sick leave or coming off sick leave, the discrimination related to disability, illness, like being discriminated against and fired because of that. Those are my favorite cases to do. And with those types of cases, I like them because, well, I guess I like them because it combines all the things that I do in one way. But I don't know. There's often I like it when there's a good villain. It's important in your legal case that there be a villain and that the villain not be you. So when you're firing people for and being insensitive around medical leave, like I have a case today I was working on where my client, they literally fired my client while he was in the way like sometimes this can work. The case I'm thinking of here is the client was on a medical leave and the employer was saying, we want you to come back. What is the date? And the employer said, we want you back by this date, which is kind of ridiculous. You can't dictate when someone comes back from a medical leave. Well, the person didn't come back from the medical leave on that date because they were an inpatient in the hospital with very limited access to a phone or computer or anything like that. So having not heard back from the employee, they're like, oh, well, I guess you've quit. And they sent a letter like out immediately pouncing on the situation to say you voluntarily resigned, so therefore we don't have to pay you anything. Goodbye. Thank you for. So I have several cases like that actually going on right now. I just issued a lawsuit on another case like that just yesterday. So that's a very common situation. In those situations, the employer is often going to get hit pretty hard on that. So they're going to get hit. They're going to have to pay the right notice. This is not a situation that you voluntarily resigned. In fact, it's now a situation where you've discriminated against the employee and you've done these aggravating factors. So whenever there is bad faith by the employer and how they go about, like something schemy, something done to take advantage of a situation, especially when exploiting the vulnerability of a sick employee, that is very distasteful for the courts, and they will award other damages on top of everything else. It's another reason I like these cases, because you're not just going after termination pay. You're also going after aggravated damages, something called moral damages, punitive damages, and human rights damages. So these cases can balloon up much beyond what the employer ever expected. And I do like to ding employers on this, because usually you just have to hit them once with one of these types of cases, and it will make a real change at the employer once they have to pay out on one of these kind of discrimination, disability discrimination employment cases. They are much, much less likely to do it again. And I expect usually the lawyers representing them are just sort of like slapping their head and say, I can't believe you did this. Often it would be an employer who did not consult with their own lawyer before doing this termination. And now they've hired a lawyer who's doing their best to put on a defense, but it's often very hard to defend situations like this. So again, those are my favorite cases. If you ever have one of those cases, please give me a call. I would love to represent you. So let's see what's next here. So with Resolute, we are very firmly only representing employees and long-term disability type cases, CPP disability, and wrongful dismissal, human rights cases. So employee only. We do have no win, no fee options when it makes sense. Some people, if we're just negotiating, if you've already been offered a very good severance package and you just want to see if you can get more, then we have options where you can just pay us a flat fee and we try to negotiate more. But the flat fee, you pay it whether we're able to get more or not. Whereas no win, no fee, you only pay us if we actually negotiate a settlement for you. We are nationwide. We are a small firm based in New Brunswick, believe it or not, with offices in Toronto, Ottawa, Halifax, and Moncton. But we do work nationally. This started when I started my practice many years ago. I slowly started representing clients across the country and then started getting licensed to practice in all the provinces. So we are a small firm, but we do operate nationally. Representing, I have clients in almost all provinces except Quebec and the territories, which have barriers. I would represent clients in those provinces, but there's barriers for inter-provincial practice for lawyers with those provinces. So it's not practical for me to do that. Otherwise, I probably would have clients in those provinces as well. Most of the work that we do here can be done easily by distance. This was long before COVID that we were doing these cases by distance, and nothing has really changed. That's why I mostly work from my basement office. So I built an office in the basement of my house. I mainly work from here. And the offices we have around the country are, I don't want to mislead people, they're not offices teamed with tons of lawyers and staff. They're offices that we have where they're available for us to do consultations with people and to have a footprint in those cities. Some of them are staffed full-time. Most of them are staffed full-time. Some of them have rotating staff. But they are not, we are a small team and we just work nationwide. When the cases go to trial, I just fly to wherever in the country to do the trial, but it's such a rare occurrence that it hardly ever happens. Most of these cases are resolved by paperwork. And since COVID, it's only become easier to do this type of work. A lot of it is now done by Zoom, with very few things now reserved for in-person appearances. So just keep that in mind. We're not the only firm that works this way, but we've been doing it a long time. So final takeaways is obviously know your rights. Not all unfairness is going to be wrongful, but many cases are. And get legal advice. You don't have to do this alone. In fact, you almost always want to get legal advice with a wrongful dismissal type case to make sure that what you're getting is fair in terms of what's legally required, Sometimes you think you should get more than what they're offering, but you'll find out, well, unfortunately, you do have an employment contract with a termination clause that limits you to the bare minimum. So yes, you've worked there for a number of years, but you're limited to the bare minimum amount payable under the employment standards. So that's often tough to be able to tell people that. All right, that is it. So if you want to get in touch with us, there's many ways to do so. You can go to our website, resolutelegal.ca, and there is a chat function that's quite useful. You can get through to us that way. You can also go down in the description below, and there's a link to request a free consultation. There's also a link down there to my, there's a link you can click on that will take you to where you can download any of my books. And I don't have my book out yet on wrongful dismissal. That's still in production. And hopefully will be done by the end of this year if things all go, hopefully earlier than that, but I'm just trying to be realistic of when I think I might be able to get it done. All right, that's all for now. I look forward to seeing you back here next time. I wish you all the best. Okay, so we're done that component now. Now we can move on to the question and answer part. I'll see if people have any questions. If not, we can call it an early day. I will be back, like I said, tomorrow to do the live call-in show. So we'll be interested to see if we have somebody brave people to call in. And on Friday, like I said, we're going to do a special edition on Friday where I will review one of these forms that is sent to someone on an approved long-term disability claim. I'm going to review the form. It's a different type of form. And I'm going to review it and give my opinions on what you would do if you get one of these forms. I want to build up a bunch of videos and live streams going over these forms. So when people call us, we can just refer them to the video. It's like, I'll probably talk for an hour talking about this form on Friday, but that you need an hour to really go through all the pros and cons and, nuances around signing and doing these forms. It's almost impossible for my staff to explain to someone who's calling in whether they should or should not sign this form or fill it out. By watching the live stream, you can have a better context and understand in your situation, does it make sense or not, with a more nuanced, long form kind of talk about the form. But you can understand, like, for everyone that calls in, I wouldn't be able to do that I would not have enough time to answer that for everyone. So that's why I like to do it on these live streams. And hopefully we will get enough people. When I keep seeing these forms come across my desk, hopefully the people will be good with us just reviewing those forms online and helping everyone else as well. Okay. Let me just check a few things. I'll wait to see if there's any questions. No, I'll just see if there's anything new. I'm constantly checking hold on a second. I'm constantly checking the Canada Disability Benefit to see if there's anything else new about that. If you're new and you don't know what that is, it's the newest disability benefit from the federal government that's launching this June. So we're getting pretty close. And I'm continuously watching for, they still have not given the application process. And there was something, I saw a video earlier this week on CTV News where they were talking and interviewing some people. And I'm probably going to review that. I'm going to do like a reaction to that video, but I'm going to wait for other news as well to talk about it. But if nothing comes out, then I'll probably just do that review. All right. So it looks like we don't have any questions. So I'm just going to take that as a good sign that I can have a little bit break off work here a little bit early today and a little bit of work to do tonight. So what I'll do is I'll see you back here tomorrow for our live call-in show. You call in by I'll have the number up on the screen, and this time I've kind of fumbled around with it here for 3 weeks. I think I have all the bugs worked out that it's going to work this week. So hopefully I'll see you back here tomorrow. I wish you all the best. Take care.